So, first thing we need to do is differentiate between law and procedure. Right? So it's best to think of the American criminal justice system as a conflict of interests. Right? So you have basically two ongoing conflicts. One is security and safety of the population, and the second is individual rights. Now, theoretically, these things are opposed to each other, right? Because if we take a crime control model and we say, we're going to ensure the safety of everyone in the country, even if that means we trample on the constitutional rights of others, or we put innocent people in prison, it's worth the trade-off. On the other end of the spectrum, right, we have due process model. Due process model says, look, individual rights are key. And if we give enough individual rights during this process, theoretically and hopefully, it'll weed out innocent people. Now we know we're going to weed out guilty people, but it's better to let 500 guilty people go free than we'll let one innocent person in jail. Right? So you have these conflicting interests. So that being said, you're going to see throughout this course that conflict of interests. Right? So you're going to see, up until the 1960s, we had very, very tight emphasis on security. Then the criminal justice revolution happened under the Warren Court, and then we moved to a due process model. Right, so this is where you have Miranda versus Arizona, your Miranda rights. This is where we see different requirements coming about in terms of warrants and search and seizure. Right, it's this period in time that was actually not too long ago. Then crime started to rise. Right, so you can see the conflict. And then we have 1970s, 1980s, early 1990s. We jump on to kind of back over to the security model. And today we're starting to kind of get to a middle ground, right? Now, neither side likes the middle ground, right? It's like I either want it all or nothing. I don't want this nice little middle ground. Theoretically, if we have two opposing parties, right, if we think about basic conflict theory or negotiation, we'll come to a compromise in that middle ground. But neither side's going to be happy, right? So criminal procedure is an ongoing developing process. It hasn't stopped developing, it keeps developing. Right? Every time the Supreme Court hears a new case involving criminal procedure, that's a new opportunity to have a new right or have a right taken away. Right? So again, it's an ongoing process because neither side is happy with the middle ground. So that being said, when we think of criminal law, we have to think about it in two distinct components. Right? So criminal law is divided into the substantive criminal law and criminal procedure. Right? So if you hadn't guessed by the title of this class, this is Criminal Law 1, Constitutional Criminal Procedure. Guess what Criminal Law 2 is? Substantive criminal law. Right? Where we get into, we'll talk about here in a second, in much more detail. So if we talk about substantive criminal law, this is what we're all familiar with, right? This is, you can't kill someone. You can't commit robbery, right? There's laws against it. That's substantive criminal law. Now, as you know from intro or from watching Law and Order, as wrong as it is, you know that generally speaking, in criminal process, criminal proceedings, the prosecutor is responsible for proving every element of a crime beyond a reasonable doubt. Now, if we looked at it at a continuum, right? So if we had, let's say, 0 on one end, so you're 0% certain, you have absolutely no certainty, it's complete doubt. And on the other end of the spectrum, let's say at 100, you have absolute certainty. Criminal law doesn't require absolute certainty, right? only beyond a reasonable doubt. Because in the law, we presume that anything is possible, right? So take an example I use a lot. Let's say you're on trial for robbing a convenience store, right? Now, your theory of the case, the theory that you're presenting to the jurors, or at least maybe a juror thinks of back in the jury room, is, you know, it's possible that aliens came down, cloned your DNA, took your persona, took your skin, rent and robbed the convenience store, and got back in their spaceship and went back to space. Is that a possibility? Absolutely. Right? Under the law, anything is possible. But is it reasonable? No. And that's where we see beyond a reasonable doubt, right? It has to be something that a person of average intelligence would believe is a possibility, or a reasonable possibility. So, when we're talking about proving beyond reasonable doubt, we talk about proving elements of a crime. Again, criminal law 2, we'll get into all the different elements. You'll look at all the different elements of burglary, robbery, rape, murder, all that lovely jazz. Also, I don't like I just said rape as somebody walked past the door. Like, probably not a great time for that, but is what it is. So, we'll get into it. But at a very high level, you need to know what we prove beyond reasonable doubt. So again, this is a review for intro. Usually we're talking, we require, under the law, actus reus. Right? It's required for every single crime. Actus reus is easy to remember because what it is in the name. It's an act. Right? So doing something. We also, under the law, presume that failure to do something is an act. Right? If you have a legal obligation or responsibility and you fail to do it, it's an act. It's an omission. Right? So let's say you have children, as unpleasant and terrible as they are. Like, I'll never have kids, dear God. But you decide, like, yeah, I want to continue with horribleness for the rest of my life. And you have kids. And one day, you say, Dr. Clay was right. Kids are terrible. I'm just going to stop feeding it. And you don't feed the kid. Kid dies. Have you committed an act? Under the law, yes. The fact that you didn't do anything when you were supposed to do something is an act. It's an omission. Other than that, acts are fairly readily identifiable as they can be very simple, right? So a conversation constitutes an act. Doing really anything in furtherance of a crime constitutes an act. So every crime requires an act. If there's no act, there's no crime. Now, most crimes also require mens rea. Mens rea, if you're trying to remember it, mental state, all right? This is basically talking about intent, all right? So there's 4 levels of intent: purposely, knowingly, recklessly, and negligently. All right, so purposely is the most severe, meaning is my goal to commit whatever act I committed. Knowingly, I was all but certain that the harm would result from my act. Recklessly, I knew better, but I didn't care. Negligently, I didn't know better, but I should have. Right? And don't worry about getting all this down. We'll get into it in criminal law 1. This is just a preface. Now, most crimes require mens rea. Some don't. Those are strict liability offenses. Right? So strict liability offense, the most famous one that we all know, statutory rape. Right? So statutory rape doesn't matter what you intended. All it matters is you committed the act. right? So let's say theoretically you go to a bar. The bar, you see a guy that you like or that thinks attractive, you go over, you start talking to him, right? And through the course of your conversation, you decide that you want to hook up. Fair. And you don't think too much of it because, you know, the guy was at a bar after all, so had drinks. He was obviously 21. But you get home and you remember my wise words of advice. You say, before we perform this act of copulation, I'm going to see your driver's license and your passport, right? And lo and behold, on this gentleman is his passport and driver's license, right? Both valid, and you have like the little black light scanner so you can see all the different stuff on it. And it says that he's over the age of 18. So you proceed to do whatever it is that you do. Next morning, you wake up and he's laughing. And you're like, what's so funny? He said, I'm 16. Guess what? Still rape, right? Still statutory rape. Because it didn't matter what you intended, right? It didn't matter that you relied upon good faith, right? That you did everything possible. All it requires is that you have sex as an adult with somebody under the age of 18. Now, they have Romeo and Juliet states where they kind of have it within an age range, right? But that's all that's required. That being said, most crimes, you don't have to worry about, they require mens rea. Now, if it requires mens rea, it's going to require something else called concurrence. Concurrence basically means that the act and the mental state happened at the same time. All right, so you can't be sitting in class thinking that, hey, I really want to kill Dr. Clay. Right? But in your dreaming about it, thinking about it, I had professors, I thought about it when I was in college. I was like, different ways that could kill them. I'm not listening to what they're saying, but I'm thinking of fun, creative ways. So you're thinking, I want to kill them. And then class ends, you chill out a little bit. And later in the day, I'm walking through the parking lot, I'm in your blind spot, you run me over, and you kill my fat ass. Have you committed murder? Did you intend to kill me at some point during the day? Yep. Did you kill me at some point during that day? Yep. Did that intent and that act occur at the same time? No. So you haven't murdered me. Now we're probably talking involuntary manslaughter, maybe, I mean, depending on circumstances, but murder, no. Now, some crimes require there to be a harm. Not all crimes require a harm, but some will. So when we think about harm, most obvious example is murder. You can't have murder without a harm. The harm being the murder. Right? So again, it just depends on the statute and how the statute's worded. If we require harm, we're going to require causation. So there's two types of causation: legal causation and factual causation, or cause and fact. Both have to be proven beyond a reasonable doubt if it's a harm-based offense. Now, when we talk about cause and fact, you probably all remember this from intro if you're with me. Let's say you want to kill him, right? And you ultimately do kill me, right, with that mental state. Who can we hold responsible? We're talking cause and fact. Cause and fact is anything that contributed to my death. All right, so are you a cause and fact of my death? Yeah. What about your parents? Did your parents contribute to my death? Absolutely. Absolutely. If your parents hadn't met, hadn't hooked up, hadn't had you, I'd still be alive. Are your grandparents a cause and fact of my death? Yes. Great-grandparents? Yes. We can trace it all the way back, right? If they hadn't done something, I would still be alive. Presuming that no one else killed me. So we say that's a little unreasonable. Like, you kill me, and we decide to like fry your parents. Doesn't seem fair. That's where we have legal causation, right? Legal causation basically asks, is it reasonably foreseeable that your actions would result in the harm? Right? Would your action result in the harm? So if you took a gun, put the gun on my temple, put the trigger, is it reasonably foreseeable that that would result in my death? Yup. Would your parents, when they decided to do what they do and have you, was it reasonably foreseeable to them that you would eventually kill one of your college professors, Dr. Clay? No, right? Like I highly doubt it's ever happened. Two people like, hey, I have anti-personality issues. I don't know. I have borderline personality disorder. Tell you what, let's hook up. Let's have a kid who's going to have serious mental disorder and decides to kill a professor that this kid has in college, call him Dr. Clay, and that's what we want to do. Even if they had that conversation, is it reasonably foreseeable? No. Right? No, it's not. And that's where we kind of draw the line. Right? Is it reasonably foreseeable? So there's one example that we'll talk about in tort law, which is different than criminal law. It's basically the civil lawsuits, right? It's an interesting case that demonstrates causation, right? The causation requirements are the same in tort law. So basically what happens is captain of a ship, fairly large ship, gets hammered, right? Comes into port because there's a big storm brewing out at sea. Captain gets off the ship. Captain, drunk, forgets to tie up his boat, right? Forgets to tie up the ship. Storm comes in, knocks his ship into like 3 or 4 other ships, and they kind of form like intertangled damage. This intertangled damage goes downriver until it comes to a drawbridge. Drawbridge doesn't open when it sees this thing coming. Why? The drawbridge owner or drawbridge operator is so intoxicated, he's passed out. So the boats slam into the bridge and cause basically a dam, which floods the surrounding area. And you have houses and people are affected, and you have houses that have mud basically up to their necks as a result of this flooding. In that tort case, it's a very famous tort case. I mean, it's got a crazy fact pattern, but it's absolutely a true one. Was it reasonably foreseeable that if you're the ship's captain, was it reasonably foreseeable that if you didn't tie up your boat, you would cause massive flooding, household damage, etc.? Court said no. Like, was it reasonably foreseeable for you to see that your boat would slam into other boats? Absolutely. Right, but was it reasonably foreseeable that the drawbridge owner would be, or operator would be drunk? No, it wasn't. So eventually those people get like screwed out of insurance money. There's a long story short of that. But it gives you an idea of like what's reasonably foreseeable versus what's not. And then we have any attendant circumstance is. So attendant circumstances, basically anything else the statute requires, that doesn't fall into one of these categories and usually makes the situation worse. Right? So think of like burglary. Burglary is breaking into occupation or a dwelling that's occupied at night. The at night is the attendant circumstance. So the prosecutor has to prove in a burglary case that it occurred at night. If the prosecutor fails to prove it, forgets to prove it, doesn't think about it, it's like, oh, it's just reasonable, like, whatever. There has to be a directed verdict in favor of the defendant of not guilty. Right? Judge has to dismiss the case. You didn't prove at night, beyond a reasonable doubt. You didn't even mention it happened tonight. Right? So that's kind of our equation for crime. We'll get into this in a excruciating detail in criminal law too, but again, it's got fun fact patterns. Then we have the other side, the side we're worried about in criminal law 1, this clause, right? Criminal procedure. So what criminal procedure constitutes is not this actus reus, mens rea kind of formal codification of the law. Criminal procedure is basically the constitutional and statutory procedures regarding criminal investigations, trials, and appeals. Right? So it covers everything from stops. When can the police stop you? When can't they stop you? Searches. When can the police search your house without a warrant? What if you have a roommate? The roommate consents and you're not there. Can the police search your stuff? Can you tell the police where to search? Can you tell the police stop searching? Interrogations. When do they have to give you a lawyer? What do you need to say? What are specific words? We'll get into that. Lineups. Do you have to partake in a lineup? If you do have to partake in a lineup, are you allowed to have a lawyer there? Trial rights. So, you have a right to a jury? How big does the jury have to be? Does the jury have to be unanimous? Does your attorney have to present a case? And it goes on from there, right? So this is all, we're talking criminal procedure. We're talking the actual process itself, but your rights along that process. And we have there's a little chart that we'll flip through fairly quickly that just shows the criminal process from beginning to end. And we're looking at every stage of that process. What are the procedures that we have to abide by? And what are your individual rights? So that gives us kind of the objectives of criminal procedure. All right, so criminal procedure, the primary goal is achieving the proper balance between the security of the state and the interest of the individual. Right? So like I was saying, finding that middle ground, even though we're never happy with that middle ground, because we always want it to go one way or the other, right? And think about it, if you're in trouble with the law, you probably want a lot more rights than if you had your house broken into where you want that person prosecuted, right? So we've tried to find the middle ground, but it's ever changing, ever shifting as we evolve as a society, as technology evolves, et cetera, et cetera. We're getting one case in this class that's called, it's Kelo or Kylo, however you want to say it, involves police using infrared scanners on people's houses, right? Well, that's new technology, relatively new. And the question comes up, can we use that? Well, that's a fairly recent case, right? And we're going to see that one of the cases I actually have added in the course syllabus and that's posted on Canvas occurred last year. Asked whether the police need a warrant to search your car in your driveway. Right? So again, it's this kind of ever-changing, ever-shifting balance. Now that being said, at least tangentially, right, criminal procedure should strive for accuracy, right? Accuracy in terms of application, also accuracy in terms of somebody's guilt or innocence. Theoretically, efficiency, right? Your rights should be set in stone. It should be a very efficient process. It helps the process move along. I mean, right now, we're talking 1 to 2 years to get to trial, not exactly efficient. But if we gave everybody all the rights that we could think of, we'd have 30 years till we get to trial. Right, so we still have to be efficient. Respect. We have to respect you as a human being, as an autonomous individual. Right, so respect is kind of a double-edged sword. On one side of it, we have to respect your rights, your personal interests, but on the other side of it, we respect you enough to basically say, well, you committed a crime, and because it was your decision, we're going to give you the respect that you deserve in terms of the consequences of your decision. Right? We also look for fairness. That'll come up a lot. There's procedural due process, there's substantive due process. Procedures are literally the procedures. Substantive due process asks, yeah, but is it fair? Right? And it can be kind of a case-by-case basis, but it is a kind of the backbone of a lot of cases that get raised. The question of, yeah, but is it fair? Like, yeah, your jury wasn't unanimous, but we don't require unanimity in this jurisdiction. But is it fair? Right? So this idea of fairness will come up quite a lot. Equality. Criminal procedures should apply to everyone that's in the same position, regardless of the color of their skin, regardless of their race, creed, religion, sexual orientation, gender identity, whatever. It should apply equally. It should inspire and be formed through adversarial proceedings. Right, so adversarial proceedings is this notion that you have one party who says, they're guilty. You have another party who says, I'm innocent. And we battle it out. Right? Unlike other countries that adopt inquisitorial proceedings. Inquisitorial proceedings basically presume you're guilty. You get up on the stand, and the judge questions you, not necessarily the prosecutor. The prosecutor can ask questions, but usually the judge questions you about everything that you did. Well, you're kind of presumed guilty. So we say you don't get a whole lot of rights there. Right? Your defense lawyer can't really do much in that situation. In the United States and other countries that have adversarial proceedings, you do get a lot more rights. And you don't have to take the stand. You don't have to violate, which would constitute a violation of the Fifth Amendment if you didn't want to. We have to have appeals, right? So the appeals is, look, adversarial proceedings, as theoretically great as they are to get to the truth, they're going to mess up. Or maybe the judge messes up, right? Maybe the judge lets a gun come into evidence that shouldn't have come into evidence because the police seized it illegally. Well, you should get at least one chance to say, hey, court system, the judge messed up here. So we give you, in the United States, one appeal as a matter of right. And then if you decide to appeal beyond that, it's really up to the discretion of the court. As the U.S. Supreme Court, if it's tens of thousands of petitions a year, here's 100 cases. So again, it's in that discretionary realm. And then finally, what should be actually first and foremost, it achieves justice. Procedural rights aren't a way to get away with a crime. Right? They're not a way to get away with a crime. You might think they are. Right? You might see people who the case gets thrown out because of police misconduct. And we're going to talk about this a little bit when we talk about the Fourth Amendment, but it's called the exclusionary rule. Right? If police come into your house without a warrant, without consent, they search, they find your massive pile of drugs, that pile of drugs is getting thrown out. And it's really hard to prove possession of drugs if you can't mention the drugs, right? So that case is getting dismissed. Now, it's not a way for you to get away with it. We have the exclusionary rule for the purpose of doing justice. And since the exclusionary rule is there to make sure that the police do their job correctly, that the police are there ethically to serve on the check on the police, right? To punish the police, not to let the offender get away. To do justice, right? Because the police are just constantly violating your rights, then what are rights? Nothing. So we say, look, you spent all this time putting together this case, and now it's gone. You wasted a lot of time, a lot of money. Should have followed the Constitution, right? That's justice. You messed up, you get the consequences. Now, does it result in somebody going free? could be potentially found guilty. In this circumstance, yes. But again, it's the idea of justice, right? That's kind of our ultimate goal. So, let's talk about the sources of criminal procedure. So this we'll discuss next class. Criminal procedure derives from very many sources. It makes the topic very complex. It's sometimes difficult to understand, and it varies from jurisdiction to jurisdiction, right? So criminal procedure in Massachusetts, I went to law school, is a lot different than criminal procedure in New York. In fact, in Massachusetts, you actually have more protections, more rights given to you than you do in the state of New York. Right? So when we go through this, we're mainly going to be looking at federal constitutional cases, right? The big one, the biggies. But we have to keep in mind that there's a lot more out there, that states can always give you more rights, right? And so that what we're talking about is kind of we're going to be talking about the floor, right? So you imagine a house, like we're talking about basically the foundation and the floor. That's not a full house. It's up to the states, it's up to legislatures, it's up to the rules of courts, etc., to fill in the rest of the house. So we're just going to be looking at the floor and the basement. So being said, if we think about sources, the primary source of criminal procedure, at least in constitutional criminal procedure in this class, is obviously the U.S. Constitution. Now, when we talk about foundation, this is the foundation. All right, this is the baseline. All right, so talk about it a little bit, but basically up until the 14th Amendment, the U.S. Constitution only applied to the federal government. So you only had the right to counsel if it was a federal trial. If it was a state trial, the state could give you a lawyer if they wanted to, or if they didn't have to. Then we used to go through the selective incorporation, which we'll talk about a little while later, in which we incorporate the 14th Amendment and start saying, okay, some of these rights in the U.S. Constitution, they apply regardless, right? They're so fundamental, they're so important that they apply regardless of jurisdiction. So we'll be looking at the Constitution, but the Constitution lays out a framework. It's fairly vague. So how we fill in that framework is with judicial decisions. All right, so that's where we're going to be looking at case law. We're going to fill in the framework and say, okay, the Constitution lays out this framework, but let's start filling in the walls. Right? How do we interpret it? Now, if you want to look at a judicial philosophy, I encourage you to look at page 12 in your text. It talks about judicial philosophies, right, from originalism to living document, etc. Then we have, and we won't get into it too much here, but it comes up sometimes, state constitutions. Right, so remember, we're just building the floor in this class. States can always give you more rights. We also look at English common law, because when we declared ourselves independent from the British, we're like, well, we could either start a brand new justice system with all new cases, all new rules, or we could just steal theirs because we're already doing it, since we're all British anyway. That's what we did. So we do look at old English common law. Actually, I'm writing a piece now that deals with English common law and exclusionary rule. Yeah, English common law does come into play. We look at legislative statutes. So again, if it's the Congress decides to give you more rights that are in the Constitution, they can. It's not unconstitutional because they're giving you more rights. Say legislature says, well, you have a right to an attorney during grand jury proceedings to be in there and ask questions. That's not how grand juries work, but let's say they say that. So we have to abide by it. We're giving you more rights. We just can't take away those rights. Now there's court rules. So one source that we're going to not really talk about too much, but we'll touch on is the federal rules of criminal procedure. So lawyers, depending on what court they're in and what type of trial it is, we have rule books. Rules tell us, basically, like any other rule book, what are the rules of the game? All right? It tells us in days, like how many days we have to file a petition, how many days we have to file an answer, how many days we have to file a reply. It tells us how do you qualify an expert witness. That's kind of more evidence law, but it gives us the rules of the game. And the court rules can be in your favor, right? They can be more lenient. They can give you more rights than under the Constitution. Agency regulations. So agencies are federal entities. Right? They come from the executive branch. So think of like the EPA, like the Environmental Protection Agency, Clean Water Act, basically gave the Environmental Protection Agency its legs. And the Environmental Protection Agency issues rules. Right? Like there's no dumping of hazardous waste into public waterways. If you violate that rule, it's a breach of law. Right? They carry the full force and effect of the law. So agency regulations can also give you more rights. We'll also look at this class, model penal codes. So when we think of like a model penal code, it's literally a bunch of law nerds get together, right? And say, if we were living in the best possible world where all the law was the same and all the criminal procedure was the same, what would it be? And then they publish it. Courts often look to model penal codes to say, well, the smartest minds, smartest legal minds, have said that this is what the law should be, or this is what the right you should have. Sometimes we look to that. Other times we have to look towards international treaties. Right? So we're signatories on the UN Convention of Human Rights. We have to provide certain human rights. Right? Why? Because we're a party to the treaty. Right? So we have to look, there's all kinds of sources of criminal procedure. Right? Like it can be overly cumbersome, it can be difficult, but I don't want to scare you. Right? This class, we're just worried about the floor. We're not going to build up the walls. We're not going to be looking at international treaties. All right, we're looking at the Constitution and judicial decisions. The rest of it, when you go to law school, you can build the walls yourself. All right, because it really depends on what jurisdiction you're in. So, that being said, if we look at the stages of a proceeding, and this will kind of give you an idea of what's to come. Right, so what we're going to do is this class is broken down, as I said earlier, into the stages of a criminal proceeding. Right? So we'll begin with the criminal investigation. Criminal investigation will encompass chapters 3, 4, 5, 6, 7, 8, and 9. Then, after we're done with the criminal investigation, like search and seizure, etc., then we'll move to arrest. Chapters 5 and 6, you'll see there's a lot of overlap. Booking and pre or post-arrest proceedings, 5, 6, and 12. Post-arrest investigation and interrogation, chapters 3 through 9. The criminal charge, chapter 12. We'll spend the whole time looking at just the criminal charge. Pretrial and motion practice, chapter 13. Pretrial motion practice, this is where we're talking about the exclusionary rule comes into play. This is where you get to have a little, like as a lawyer, this is kind of the fun stage. But it's also the stage that impacts whether you'll have a trial, whether you have a guilty plea, how good the guilty plea deals are, etc. Then we'll look at trial, again in chapter 13. Then we'll move into your rights during sentencing. And then we'll talk about appeals and post-conviction relief. Right? So we're going through the whole process. Theoretically, by the end of this class, you should be able to articulate most of your rights depending on the various stages of where we're at in the criminal proceeding. So, I'd like to introduce you to this clusterfuck. This clusterfuck is the criminal justice system. Right, so this is a fun chart. I don't show this one in my intro because I don't want to scare the shit out of them. But this is the criminal justice system. This is why it's so important as we go through to know where we're at in the criminal justice system. Because you can go up, down, over, back, down, over, like we can follow numerous paths. Right? And I don't know if you can read this, but there's a note on this. It says, this chart is an oversimplification of the criminal justice system. Yes, this is a simplification, oversimplification of the justice system. All right, so we need to know where we're at. So theoretically, on this side, things kick off with a crime. Right? Then we move into the entry of the system. Entry of the system, we're talking to this light blue here. So this could be reports or observed crimes, this could be through investigation, whatever. Then we move into the dark blue, right? If we decide that we're not going to just make the thing go away, we'll move into the dark blue. Now the dark blue is broken down into kind of three subsets. Felonies up at the top, misdemeanors here in the middle, and the juvenile offenders down here. This is the prosecution and pretrial services, right? So this is before we even get to trial. Now, once we come over here, in the purplish, you see adjudication, right? Adjudication, this is the trial. That's just the base name for it, right? It's kind of the beginning stages of the trial and the trial itself, right? Where we're starting to decide whether you're guilty or whether you're innocent. But you see, we can come down, and we can kind of look down here. We can go back. We can go down here. We can go back up here. We can flip-flop around all we want. Right? So there's numerous ways to kind of restart this thing. But if we hopefully, theoretically go through the process, we're just talking felonies, like a little bit easier to understand. Then we get to sentencing and sanctions. That's going to be in the orange. You'll see there's not as many rights in terms of sentencing and sanctions. And then we get to yellow, which is corrections, right? And generally like post-appellate relief. This is where we see a lot more rights come into play. So if you kind of look at the stages in terms of length, like length of the arrows and things like that, gives you a fair idea of where we're going to spend a lot of our time. All right, so here in the crime section, it's huge. We're going to spend a lot of time post-crime talking about search and seizure, arrest, etc. Then we have charge. Once we have a charge, we begin the prosecution of pretrial services. That's going to be a long length of time. We'll talk about adjudication. Well, it's about medium size. Sentencing and sanctions, fairly small. At this point, you don't have that many rights. And then once we go to corrections and appeals, then we see it starts to open up again and become bigger. So this is the system that we'll be looking at. Again, keep in mind this is an oversimplification. Not meant to scare you. You're not going to have to know like all this stuff for an exam, but just an idea of this is why it's so important that we know where we're at in a criminal proceeding. Because your rights here are a lot different than your rights here, right? A lot different. Things change. And we'll get into all that. We'll go slow. We'll dip our toes in the water. And I promise you we'll get interesting again in the case law. So one thing to know, right, is we have a federalized court system. Again, for the intro, this probably looks familiar to you. We have the federal courts. We have the state courts. Right, so we don't have one justice system in the United States. We basically have 51 justice systems, right? 50 for the states and 1 for the feds. If you want to count the territories, et cetera, you can. That being said, most of our cases will deal with federal law, federal constitutional law, but there'll be state-issued proceedings. Now, for federal cases, they're fairly easy to understand, right? So for our purposes, we look at federal courts. Look down here at the bottom where it says trial courts, courts of original jurisdiction. For our purposes, all we care about is the U.S. District Court. Small Claims Division, U.S. Tax Court, not our problem. Federal District Court, that's where you go have your trial if you commit a federal offense. Then remember we said you get an appeal as a matter of right. So we'll go up to the U.S. Court of Appeals. Now, I worked for the U.S. Court of Appeals for the First Circuit, right? So I worked with Judge Torrea. He is the judge from Puerto Rico. So First Circuit, you have Massachusetts, and you also have Puerto Rico. And then you have the bordering states, New Hampshire, et cetera. And that was just because it was easy to do. Right? Basically, all the companies that owned the sugar cane in Puerto Rico were based out of Boston when we created the system. So you can just go to Boston. So this is a matter of right. Court of Appeals has to hear your case. Now, it doesn't mean they have to have a full hearing, but they have to read through it, maybe meet in chambers, issue a decision. It doesn't mean every time you get oral arguments. Right? Actually, most cases don't get oral arguments, but you can. And if you don't like your problem here, then you can go up to the U.S. Supreme Court. Again, they can choose to take it or not. Up to them. Then we have the state courts on the other side. And I published for you New York, because, well, we're in New York, but to let you see how New York does things. So what we're concerned about in New York is this far left box here. Well, I mean, they're all relevant. But generally speaking, the trial court for felonies is going to be the New York Supreme Court. Now, basically every other state in the country calls their top, highest court the Supreme Court. So like the Supreme Court of Missouri. New York, because it's New York, said, no. You'll have a trial in the Supreme Court, and then you can get an appeal up to the appellate division of the Supreme Court. And if you don't like the outcome there, then you can go up to the Court of Appeals, which again is the highest court in New York. So it's helpful to know structures. The hell? Okay. So it's helpful to know structures. To know where you're at, right? So obviously Supreme Court, we're dealing with felonies, county courts, district courts, non-felonies. We're talking city courts, town courts, village courts. You're talking basically like low-level misdemeanors. But they all kind of go up to the Court of Appeals. So just know that if you see something in your book, it says Court of Appeals, chances are it's going to be the middle appellate court. Unless it's New York, then it's the top. Right, so it's the one little caveat. So this gives you an idea of some other kind of normal, like other courts that to be aware of that have a little bit different proceedings. New Hampshire, 2 people and a moose live in New Hampshire. So we have circuit courts, which are non-jury trials. We have superior courts, which again are just original jurisdiction. They're based on the same level. They have jury trials. If you don't like what happens, you can appeal, right? You get an appeal as a matter of right. But because only 2 people and a moose live in New Hampshire, you go right to the New Hampshire Supreme Court. New Hampshire Supreme Court has to hear your case, or has to consider your case. It's just because there's no reason to have a middle appellate court. Right? There's not that many people there. Case loads are different. There's no reason to have a middle court. We know everybody's going to apply to the Supreme Court anyway in New Hampshire, so we might as well just go to the Supreme Court. Right? That's kind of the thought process behind that. If we flip over and see Alabama, Alabama does things slightly differently too. Again, you don't have to worry about municipal court or probate court, but here we have circuit courts, which are non-jury trials, and then we have district courts, which are jury trials. So again, names will change. Don't get thrown. But we look at their appellate court. They actually have a medium or a mid-level appellate court, but it's broken down into 2 separate categories. So we have a civil court of appeals, Alabama Court of Appeals, civil division, and then we have the Alabama Court of Criminal Appeals. Now, why did they have 2? it basically is a long history, but it exists to this day to kind of like speed up the criminal process, specifically in death penalty cases. That's kind of to make that process go quicker. But you'll see it ends in the same way as virtually every other state in the country except for New York at the Supreme Court, right? The Alabama Supreme Court. So, when I was talking about numbering divisions, I said, I worked for the first district court. This is obviously the United States, right? If you didn't know it was the United States, I feel very sorry for you. I need to have a conversation with your civics teacher. But this is the United States. You'll see it's in this lovely colors. The lovely colors represent different districts, or excuse me, different circuits. You'll see, the thing is easiest to see here in California, you'll see there's lines that break up the state. Those lines represent different districts. Right? So when we start a case at the federal level, we start at the federal district court. Well, we break up the districts based upon population. Right? So it's California. Depending on where you are in California, there's either a lot of people or no people. Right? We said, well, it's not really fair, especially California, considering how long it is, to the people up here to have to go down here for a trial. Right? So we break it up and we say, okay, we kind of do around population centers and consider distance, etc. So that's where you have your trial. And if you don't like the outcome of your trial, you go to the U.S. Court of Appeals, U.S. Circuit Courts of Appeal. In this case, if you're in California, you go to the Ninth Circuit. Ninth Circuit encompasses California, Nevada, Arizona, Idaho, Oregon, Washington, Montana, Arkansas, the Northern Mariana Islands, Guam, and Hawaii. So theoretically, if you are in Alaska and you don't like the outcome of your case, you get to go to Sacramento, California, which is where the U.S. Court of Appeals sits. All right, so again, if we flip back over here to the First Circuit, we've got Maine, Rhode Island, Massachusetts, Puerto Rico. Right? We go to the Third Circuit. Third Circuit includes the Virgin Islands. Just does. Second Circuit, New York, Vermont. These are population centers. Right? So we got to get out here where there's not that many people. We see more states get incorporated. Right? The flyover states. It's just out of convenience. Right? So again, if it says something like in the Ninth Circuit, I'll tell you this Ninth Circuit is kind of the infamous circuit. This is where most of our controversial opinions come from. So Ninth Circuit is very liberal in its approach most of the time. So when we talk about marriage equality cases, they came from the Ninth Circuit. A lot of constitutional law issues come from the Ninth Circuit. It's kind of our, all right, Supreme Court's going to take it state, right? Or circuit. But I mean, the Supreme Court can take anything from any circuit and they can change the law. But the Ninth Circuit is just kind of infamous as being that court, right? That's like, no, we're going to push this and see where we can take it. So that's overview of the feds. Now let's look at the sources of binding procedure again. This just gives you a different model of what we talked about a little bit earlier, right? So if we think about a pyramid, let's think about the courts as a pyramid. All right, at the very bottom of the pyramid, we have the federal constitution, right? So then when I talk about we're building the floor in this place, we're talking about most of what we're doing is going to be here. Federal Constitution and federal Supreme Court decisions, right? But you see, they start to get more narrow, right? So again, this is very broad, loose interpretation. This gives us some interpretation. This gives us more interpretation, and then kind of narrow it down, right? So we're also bound by congressional statutes. This includes international treaties. Then we have state constitutions. State constitutions kind of narrow down meanings a little bit more. Again, applies to state prosecutions only. Then we have state Supreme Court decisions or appellate court if you're in New York. Then we have the rules, including the rules of court. and the rules of procedure. Right? So again, it's kind of what we talked about, but just gives you an idea of where we're at. We'll be in the basement. You can always get more rights as you go up, but we'll be down here just at the bottom level, like these are the bare minimum rights. So, U.S. Constitution. So let's talk real quickly. It is the primary source of due process, the primary source of law in the United States. Right? It is the supreme law of the land. So that being said, for as great as it is, the Constitution has been amended several times. All right, so most of what we're going to be talking about is going to be down here in the Bill of Rights. That being said, the Founding Fathers weren't so much concerned about criminal proceedings as other things. In fact, there's only 4 references to in the original Constitution, ratified 1788, right, that provide anything to do with criminal procedure. So Article 1, Section 9, deals with habeas corpus. Basically, it's Latin for bring me the body, bring the body to me. Article 3, Section 2, ex post facto laws. Basically, you do something, and then we pass a law that says it's illegal. We can't try you for something you've already done that wasn't illegal at the time. Jury trials in the district of offense. Article 3, Section 2. The only crime listed in the U.S. Constitution is treason. Article 3, Section 4. And we'll probably never have a real treason prosecution again in the United States. Because for treason prosecution, you have to have, according to the Constitution, 2 separate eyewitnesses. Now, treason is obviously a death penalty offense. It's really hard to prove. It is what it is, because you have Constitution, you have statutes, you have all these things come into play. So it'd be different than if we had like espionage, right? So this is all that gets mentioned. And for your reference, in case you don't know, Article 1 deals with Congress, Article 2 deals with the President, Article Executive Branch, Article 3 deals with the Judicial Branch. Article 3 is the shortest part of the Constitution. It is 2 paragraphs long. It sets out the Supreme Court, what treason is, and says, look, Congress can make other courts as it sees fit. Like, that's it. So, that's not really a functioning system. So in the Bill of Rights, ratified in 1791, then we start to see, okay, here's where our criminal rights come from, right? You get that much from the base of the Constitution, you get it in the Bill of Rights. Search and seizure, warrants, Amendment 4. Indictment, due process, again, substantive, right? Due process. Double jeopardy and self-incrimination, Amendment 5. Speedy, public, and partial jury trial, confrontation clause, and the right to counsel, for Amendment 6. Excessive bail, fines, cruel and unusual punishment, Amendment 8. All right, so kind of these middle amendments are the ones that we are going to be most concerned with in this class. Now, we talked about the application of the federal Constitution, which brought this up a little bit earlier. Generally, we're talking about selective incorporation. Right, so what we've basically said is the Constitution applies to the, quote, fundamental rights, such as those included in the Bill of Rights. Right, so again, prior to the 14th Amendment, which is the Civil War amendments, right? Federal Constitution only applied to the feds. The U.S. Constitution only applied to the feds. States can do whatever they want. Then we have the ratification of the 14th Amendment. The 14th Amendment has a due process clause that matches the due process clause in the federal Constitution, right, that it amended. And we start to say, okay, fundamental rights, we're going to start applying them to the states. And we did it on an ad hoc basis, right? So basically, as an issue came up, the Supreme Court would hear it and say, yep, that's a fundamental right, the states have to abide by it, or nope, not a fundamental right, the states can do it if they want to, don't have to do it if they don't want to. where we see the largest procedural constitutionalization and incorporation is in the last half of the 20th century, primarily with the Warren Court. Right, so it's Chief Justice Earl Warren, it's U.S. Supreme Court. We call Supreme Courts we give them names based on who's the Chief Justice. Right, so right now we're sitting in the era of the Roberts Court. Back then we were sitting in the era of the Warren Court. Now, the Warren Court didn't really get involved too much, dive into too much detail until the 1960s. Then it just went nuts with like giving rights. But we do have some that was, again, ad hoc, right? So, for instance, when we're talking about criminal procedure, criminal law, the idea of when can we punish, what's right to punish, what can we procedurally make criminal, what's substantive due process, what's fair to make criminal. We come along with Roshan. So, who feels like exercising your knowledge? I see your hand is up, and I appreciate the volunteering, but I feel like you want to tell me about Roshan. What happens in Roshan?
So you swallow pills to like find the evidence and the police kind of forced him to go up and kind of stop on his stomach when he took him to the hospital. Basically understand it.
Okay. So where were the pills? They were on the nightstand, right? Like they were in this bedroom on the nightstand. Things come in. I think there were only 2 pills. Like, they like, no, fuck this. Like, he takes the pills. Police are like, no. So yeah, you're right. They absolutely did. They tried to force the pills out. They take him to the hospital. Basically, give him the pills, get the pills out of the system. Can identify what the pills are, and then they charge him with possession of these drugs, right? So he gets convicted. It goes through the process up to the U.S. Supreme Court, and the U.S. Supreme Court says, what? Is this cool or is this not cool? This is where I'll move to my volunteer. What did the Supreme Court say? Okay, couple things. You speak up, have confidence, and nail it. So try to get it.
So the precedent, it seems that it wasn't basic and that they didn't even want it.
Absolutely, right? They said, hey, what you did's not cool. It's too invasive. So because it's invasive, you have to have a warrant. You didn't have a warrant. The pills are excluded. We're sending it back down for a new trial. Guess what? Hard to prove possession of drugs if you don't have the drugs. This is kind of ultimately what happens. But it gives us a point of selective incorporation, right? We said substantive due process, right? Is it fair? Do we want police doing this? Right? Or do we need a court to supervise? So that's what we're coming in with Roshan, right? Roshan kind of comes in as an ad hoc addition, saying, look, if it's invasive or if it's too invasive, then no, it's not going to fly. So if we look at Amendment 14, in addition to thinking about it in terms of selective incorporation, it also provides equal protection under the law in criminal procedure, right? So for instance, we look at U.S. v. Armstrong, which normally I would call on somebody who was bold, but just for sake of time. U.S. v. Armstrong deals with selective targeting, basically, of certain individuals. All right, so it can police target people. In this case, it was involved color of skin. And the Supreme Court came out with a kind of a weird opinion. It said, like, well, if you want to say that you're being selectively targeted, that's fine. But you have to prove that somebody else in that same situation wouldn't have been arrested. It's a very difficult thing to prove, right? So you have equal protection. Yes, we're saying that it's equal protection is a fundamental right. The states have to abide by it, but there's a trade-off. You have to prove what is kind of ultimately an unprovable thing, right? So again, it's ad hoc. We're just dealing with rights as they come up. So the Supreme Court, like I said, fills in the gaps. So if we take, for example, the right to counsel, Amendment 6, it provides, in all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense. Okay? Seems straightforward until you say, well, when do you actually get this right? Before an arrest, after an arrest, during a search, before a search, after a search, when do you get this right? Who pays for the attorney? Do you have to pay out of your own pocket? Like, yeah, you have the right to an attorney if you can afford one. That was the rule until we had Gideon v. Wainwright. Is this only at the federal level? Or does this apply to the states? Right, so all these questions come up. Each of these are separate questions that a case raises, or that cases have raised. So like each one almost represents a case. And the Supreme Court has to basically take this Constitution that seems decently straightforward, but it has all these caveats, right? Like when, who pays, all this stuff. The Supreme Court has to be and is the final arbiter of the Constitution. They get to say what it means, right? So under supervisory authority, interprets the Constitution and applies it through a process of judicial review. So most of you know the case, Marbury v. Madison. This is basically the case where the Supreme Court said that it was the final arbiter of the Constitution. So prior to Marbury versus Madison, the Supreme Court met in a cloakroom of the U.S. Capitol building. You can actually still go there. They preserved it, but it was in the cloakroom. It didn't have its own building until the 1930s. Right? It was 2 paragraphs long. Nobody cared about the Supreme Court. Marbury versus Madison, they got a little pissed off. They're like, we're tired of being like the crappy branch of government. So we're going to say that we get to determine what the Constitution means. We get to determine whether laws are constitutional or unconstitutional. We get to determine whether conduct is constitutional or unconstitutional. Okay? So Congress responds by saying, we're going to pass statutes basically taking away your authority. Guess what? There was a lawsuit. Where did the lawsuit go? The Supreme Court. The Supreme Court changed its mind? No, it didn't. Right? So that's how we get to Marbury versus Madison. Marbury versus Madison is where we change our mind and say, suddenly the Supreme Court is important. The judicial process, judicial review, all come into play. Right? And that being said, as we learned in McNabb, the court may also impose and interpret procedural protections beyond those found in the Constitution. Again, this kind of comes back to substantive due process. Is it fair? This often serves as a point and a place of contention of judicial activism, right? Judicial activism is basically a court is now making the law when the legislature is tasked with making the law. One key example that we all actually like, for the most part, of judicial activism, when everybody's like, oh, judicial activism is terrible. Well, Miranda versus Arizona was judicial activism. Yeah, the Miranda rights, this is where the Miranda rights come from. You have the right to remain silent. Anything you say can't be used against you in court of law. You have the right to an attorney beyond 431, you right to you for questioning. Do you understand your rights? Comes from Miranda versus Arizona. It's a question. Where did this statement of your rights come from? That you have to be informed of your right to counsel. You have to be informed that even if you can't afford it, we'll provide it to you. Be informed that if you say something, we can use it against you. Right? That little spiel that we go through. Where did it come from? Supreme Court made it up. And guess what? You can't argue with the Supreme Court. The only way to overturn a Supreme Court decision is via another Supreme Court decision or a constitutional amendment. They made it up. They said, you don't have to say exactly what we just said, but as long as you come close, you're good. Right? And we'll get to Miranda versus Arizona, all of its lovely details, but it's an example of judicial activism that was, the court gave itself the permission to do in McNabb versus United States. Again, just touching on this, each state has its own constitution. Constitutions in states can provide you more rights, right? You know, talk about Massachusetts, provide you the most rights in the nation. Like if you're gonna go commit a crime, go do it in Massachusetts. Like you get rights out the wazoo. The least protective is Florida. Florida basically says, hey, whatever the Supreme Court says that we have to do, we'll do that. Nothing else. So Florida's like the base. You know, go commit a crime, don't do it in Florida. Right? Like, so if you go to spring break, maybe go down to Texas versus Florida. And I know you're thinking like, Texas? Like not great still, but better than Florida in terms of the rights you get. Right, so South Pedro versus Panama City. Just helping give you some spring break ideas. Start planning now, right? I wouldn't book anything until we see how this COVID thing works out. But yeah, it's a good time to start doing plans. We're already started the school year while you're still fresh and excited to be here before your souls collapse. Start planning now. So that's kind of our spectrum, Massachusetts to Florida. Now, the state and federal statutes, they can be equally as protective or more protective than state and federal constitutions. Let's say again, we're more and more protective. So for instance, we have the Speedy Trial Act. Amendment 6 says you get the right to a speedy trial. And we kind of just before based that on fairness. We're like, okay, is it really fair that you have to wait 3 years? No. Like we just kind of based on fairness. Then Congress passes the Speedy Trial Act. Speedy Trial Act says in the prosecution of a felony, from the date of arrest, you have 100 days to get that case to trial. Does that happen? No. Not at all. Right? The legislation provides tolling provisions. So let's say that, and it's usually like defendant based. So let's say the defendant requests a continuance, or the defendant requests funds for an expert and time to have that expert. Well, we stop the clock. We say, okay, this time doesn't count because you requested it. But if the prosecution requests a continuance, that clock keeps going. Right? So the 100 days, basically what happens is the charges, they get dismissed. Now the court that dismisses the charges can do it one of 2 ways. One's called with prejudice, one's called without prejudice. With prejudice means you can't bring those charges again. Without prejudice means you can do it under arrest and bring those charges again, but with a strong admonition. That being said, it really depends on how bad the state, prosecutor, police, whoever, fucked up and not getting your trial that quickly. They made like a huge mistake, like trampled all of your rights. That court's gonna say, nope, you had your shot, you wasted it. And courts are gonna kind of lean that way. But in some cases, it's like, hey, you were over by a day, there's tolling that took place, we're discussing it, it's up to you to bring it again if you want to, but we recommend you don't. Right? Like we're gonna be extra harsh on you next time you bring it down. So that's kind of where we're at in terms of the Speedy Trial Act, right? You get more rights, right? You get 100 days. Never happens. But theoretically, it has to be 100 days. Congress gave you more rights. And then state and federal rules of criminal procedure can give you rights on top of that, right? They're created by state and federal courts and then ratified by the legislature. So the Federal Rules of Criminal Procedure actually came from the US Supreme Court. Supreme Court said this is what we think the rules should be. Congress said, cool. Congress passed the law. Now we have these rights, right? So again, I made it clickable. If you want to click and look at the Federal Rules of Criminal Procedure, you can click on it and look at Federal Rules of Criminal Procedure. It goes in order of the trial. Tells you days, tells you all that stuff, right? And trust me when I say, like, we had a motion to dismiss one time. I was working with the Coast Guard for violating the Speedy Trial Act. And there were 4 attorneys and myself sitting around a desk calendar counting days, like trying to figure out if we violated the 100 days or not. That's again, always being protected. So that being said, you made it through it, right? You made it through like the what I would call informative but dull part of class, which means that next class we get to start with the fun stuff, right? And we'll eventually answer that question that I know you all want to answer: when can you go tell a cop to fuck himself? Right? Like you all want to know that inherently. I think we all do, right? Like you just want to be like, especially if you get pulled over, you just want to be like, fuck no. Can you do it? Yes. When can you do it? We'll talk about it. Will you get tased? Probably. We'll get all of that. The next class we're going to look at introduction to search, seizure, and the reasonable expectation of privacy. So we're actually getting into what your rights are next class. Any questions, comments, concerns? How about our friends online? Any questions, comments, or concerns? They're probably asleep. So, that being said, have a great day. I will see you all on Thursday.